going to learn a whole lot of law. Actually, this whole week, administrative law. So we are going to learn a bunch of stuff that is important. Some of it's tested on the bar exam. Some of it's a little con law review and that sort of thing. A lot of, everything we do relates to any time you're going to be dealing with an administrative agency or litigation involving an administrative agency. We're going to focus primarily on federal administrative law because that's the bulk of what environmental law is, but there's state administrative law, and even at times there's a sort of element of local environmental law. The local stuff you will get in land use if you take that next semester. So we're going to do quite a bit. Huge PowerPoint that covers both classes, both today and Wednesday. So fasten your seatbelts. We're going to go through a lot. Then next week we have no class on Monday, right? We have Labor Day, yes, already holiday. Woohoo! There is a big chunk of reading for next Wednesday, 82 pages worth. So just a heads up. And it's really all about how environmental law is changing. So it's not a bunch of sort of in-depth cases and so forth. But we're going to spend 2 class sessions on that. So maybe send out some emails at some point, maybe before next Wednesday, or possibly between next Wednesday and the following Monday, about how we're going to cover a little bit of that. So just a heads up. And then we start getting into some very specific statutes: the Endangered Species Act, the National Environmental Policy Act, statutes governing federal lands management, and so forth. Okay? So that's what we're doing now. So we're going to rock and roll. If you are in the environmental field study class and you either are kayaking this Friday or you are wanting to kayak this Friday but didn't let me know by noon today, as the email requested, stay for a couple minutes after class, and we'll talk about that. If you are doing it, I've got a couple things to sort of guide you. If you want to do it and haven't signed up, I can give you some guidance about how to do that. Okay? So that's the environmental field study, folks. All right. Administrative law. So environmental law is very much tied up with the rise of the administrative state. And a big part of the rise of the administrative state was the New Deal in response to the Great Depression, the Franklin Delano Roosevelt administration. But even before the New Deal, around the turn of the century, in the late 1800s and early 1900s, the federal government was growing, and new administrative agencies with new powers and authorities were being created in the federal government to address the environment, in particular management of federal lands and resources. And so a lot of this stems, especially the issues related to federal lands and federal resources, go all the way back to the U.S. Constitution and the Property Clause. Okay, so Congress has the authority to create ways of managing its federal property. But then in the late 1800s and into the early 1900s, Congress started enacting statutes that were designed to create entities to do that and to grant them the authority to do that. So an example is the 1897 Organic Act, which had to do with the management of the national forest. Actually, primarily, interestingly enough, for timber stocks for the Navy. There was a national security issue, and then also water and watersheds, and in part because there was so much logging going on in the national forest, it was causing massive erosion and flooding. And then what happens is the administrative agency, then develops a set of regulations that implement the statute, and in particular, the agency develops not only specific regulations to implement specific statutory mandates, but they adopt general regulatory schemes to guide the agency in how it's going to exercise its authority. So, one of the things that started happening as you had a variety of administrative agencies and administrative authorities being created is the courts sort of got involved in trying to figure out what's the relationship between the legislative power and the administrative agency's power. And when the legislative body, and at the federal level, of course, that's Congress, or in the state level, it's the state legislature, or at the local level, it's going to be the city council, or fiscal court if you're at the county level, that kind of thing. And the question is, when that legislative body grants authority to the administrative agency, is the legislative body basically giving away its legislative power? If it is, that violates the separation of powers, right? If basically Congress enacts a statute that says we are going to create an administrative agency of good welfare for all Americans, right? So the Good Welfare for All Americans agency, and we're going to grant them the broadest authority possible to regulate in order to protect the welfare of all Americans. Okay, well, that's very broad, right? That's arguably what Congress is supposed to do, right? And so the question is, at what point has the legislative body delegated its legislative authority? And so they developed what was called the non-delegation doctrine. It said that administrative agencies cannot exercise legislative authority. That violates the separation of powers. However, fairly soon, for those of you who've studied constitutional law, certainly by around the time that you have the switch in time that saved 9, right? Does everybody know what I'm talking about? Where the Supreme Court suddenly decided that the New Deal was constitutional rather than unconstitutional, and so forth, that what you started getting was a series of judicial decisions that say broad delegations are legitimate. They are permissible so long as there is, quote, an intelligible principle to guide the agency. So as long as there's an intelligible principle to guide the agency. And that has been the standard. Okay? And those of you who are familiar with the Commerce Clause cases in constitutional law know that there was a long time between the New Deal until just maybe the last 20 years where the Supreme Court kept saying the Commerce Clause is very broad. Surely there's some outer limit, but we've never met the outer limit, right, of the Commerce Clause. Well, the same happened with the non-delegation doctrine. Surely there is some outer limit where you no longer have an intelligible principle, but we can't possibly even begin to imagine what that is because all sorts of things count as an intelligible principle, right? Is everybody following the kind of gist of that? Okay, so what has happened recently? Just in the last term, there was a case called Gundy where it was basically a 4-4 decision because I think it was Gorsuch that didn't participate in the case. It wasn't on the court when it was first argued or something like that. But anyway, but there was some language in. Now I can't remember. I don't think it was a dissent. I think it was a concurrence. But it suggested that there might be now in the Supreme Court 5 votes to overrule the intelligible principle and resurrect the traditional non-delegation doctrines, prohibition on broad delegations. Okay, so that is possible. Okay, I think this is going to be like the Commerce Clause. I think any time the Supreme Court says there are some outer limits to some aspect of the U.S. Constitution, in this case it's separation of powers, but we don't know what they are, that at some point, after some decades have passed, the Supreme Court is going to find what those outer limits are, and they're going to articulate them. So, does that sort of make sense to folks that, okay, after the Commerce Clause cases, right, we have Lopez and, I'm forgetting, Morrison, I think, right? And, right, the handgun, you guys are looking at me like, right, handgun in school zones and what, right? Okay, so the Supreme Court finally said, oh yeah, the Commerce Clause is really pretty broad, but it's not limitless, okay? The power of the legislature to delegate authority to administrative agencies is pretty broad, but it's not limitless. Not everything counts as an intelligible principle. That's what I think we're going to find with the Supreme Court. I don't think we're going to suddenly find the entire elimination of the administrative state. Some people are worried about that. Some people are hoping for that. But I think neither of those is very likely. I think what's likely to happen is that we're going to start getting more law about what counts as an intelligible principle and what the outer boundaries of this are. So anyway, so what I'm saying is environmental law is changing as we speak. And so this is one of the areas where it's changing. And by the way, that slide right there, all entirely new as of in the last couple of days. So this is different slide. That one I just gave was a different slide than what I gave 2 years ago because we didn't have Gundy, we didn't have the Supreme Court say that. Okay, so this is basic diagram of the various branches: legislative, executive, judicial. The power to create rules and regulations is granted from the legislature. The power to investigate, prosecute, advise, and supervise is an executive power that's given to administrative agencies. And the judicial power, there is going to be some judicial decision-making within administrative agencies by administrative law judges and other adjudicatory bodies within the administrative agency. Okay, so if, for example, you violate some sort of permit, your first stop might not be the courts. Your first stop might be some sort of administrative adjudicatory officer who's going to decide whether indeed you really did violate your environmental permit or not. So here's a list of the various agencies federal agencies that deal with environmental issues. So of course, the most obvious is the U.S. Environmental Protection Agency, or the EPA. As I was mentioning the other day, the U.S. Department of the Interior it plays a major role. We have the U.S. Fish and Wildlife Service, the National Park Service, the Bureau of Land Management, the Office of Surface Mining and Reclamation, and the Bureau of Reclamation. Within the U.S. Department of Agriculture, or USDA, we have the U.S. Forest Service and the Natural Resource Conservation Service. So one of the key things here, this is something that people get hung up on. Our national forests are not managed by the Department of Interior or by the National Park Service or by the National Fish and Wildlife Service. They're managed by the U.S. Forest Service, which is actually in the U.S. Department of Agriculture, because timber from the forest were originally seen like, harvesting wheat or corn or something like that. Okay, so that was sort of the idea. The Department of Defense. We talked about the U.S. Army Corps of Engineers the other day. So they have significant environmental regulatory authority. U.S. Department of Commerce has NOAA, National Oceanic and Atmospheric Administration, and the National Marine Fisheries Service. Sort of at the White House level, we have the Council on Environmental Quality. The U.S. Department of Energy has a role to play, the Nuclear Regulatory Commission, and then not up here are things like the extent to which the U.S. Department of Transportation deals with environmental issues related to building and maintaining federal highways and so forth. So the point here is that there is a large, extensive, massive, multi-dimensional regulatory framework, administrative agency framework within the federal government. Okay, a bunch of different agencies all involved. And so one of the things we talked about the other day is the extent to which all these agencies cooperate, the extent to which they may have conflict or tension over who has what authority, and conflict or tension over who gets what resources and power. Right? So with the rise of the administrative state, we see that administrative agencies have a significant number of different functions, including regulating behavior, managing resources for the government and the public, making plans and policies, administering programs, funding, and information, studying problems, issuing regulations or rules that effectuate purposes and directives of statutes, all the way from general standards to specific, particularized, or localized standards, and permits to ensure compliance with rules and regulations. And agencies enforce both the statutes and regulations through compliance actions, civil and criminal penalties, and other administrative actions. Okay? So all of this stuff is being done by the administrative agencies, and we haven't even gotten to court yet. Okay? And down here we talk about, okay, yeah, they're going to take you to court, but all of this is what the agencies themselves are doing. And by the way, I'm going to post this after Wednesday's class on Blackboard, so you don't have to frantically type every single word that's up here. This will all be on that. Okay, so public participation is another part of how the administrative state has evolved in the U.S. So some of this is from the very beginning, but much of it is much more recent, where in the last few decades, the public has demanded the right to have the opportunity to participate in various kinds of administrative agency decision-making. So we have stakeholder opportunity to participate in decision-making processes. We'll talk about notice and comment rulemaking in just a second. So if that makes sense to you, hold on. Be there in just a second, but that's an example. The rights of the public to have information on the environmental impacts of actions that the agencies are considering, and to require the agency to gather, release, and consider that information. And that's the National Environmental Policy Act. We're going to spend a class session on that. Information disclosure required. So a classic example is what's called the Toxic Release Inventory, or TRI. It's a little corner of environmental law, very important. If you are wanting to know if there are any toxic chemicals that have been spilled or released into the air, released into the water, whatever, spilled on the ground, etc., in the area around where you live, you work, you have clients, your clients are considering buying property, etc., okay, you can find this information from the federal government on the TRI, Toxic Release Inventory. That it is a system in which there's, the regulatory requirement is you have to report it, right? You have to disclose that it happened, but by itself, the TRI doesn't prohibit the spill or the release. That has to do with other statutes. All it says is you have to let people know. And so if you are, for example, looking at Louisville, and you look at the TRI, you're going to find a huge number of these incidents where? West End, West Louisville, Rubbertown area and so forth. Some on the south end, areas around the airport and so forth. Okay, but as you might imagine, areas that have more industry, areas that have more contaminated sites and so forth. Okay. Advisory boards. Many agencies have advisory boards, and there are specific statutes and regulations regarding how those get set up, how they operate, who gets to be on them, etc. The public has opportunities to appeal agency decisions, to seek judicial review. We're about to turn to citizen suits here in a few slides, and so that is key. There are an increasing variety of mechanisms by which the public participates in administrative agency decision making, and by which the agency has to publicly or visibly deliberate about its decisions, as opposed to making those decisions, in private behind closed doors and not disclosing why they decided what they did. Okay? Public education is a way in which the agencies engage with the public and try to get people to not pollute the streams, or not litter, or etc. And then we're going to spend some time on and off throughout the class talking about collaborative problem solving, the ways in which the administrative state has evolved to try to get various stakeholders to come up with cooperative solutions to environmental problems. And to some degree, those can be participatory, but they can also involve avoidance of statutory mandates, basically kind of an in-run around what the regulated entities are supposed to do under the statute. Okay, so now we're going to turn to the Administrative Procedure Act itself. Okay, so the APA, or Administrative Procedure Act, is the basic framework for understanding the law governing the administrative state. It is not the only source of law, but it is sort of the starting point, the basic framework. Okay, and so a basic of administrative law is that you have to understand the differences among formal rulemaking, formal adjudication, informal rulemaking, and informal adjudication. Okay, and despite this standard type of box that shows what's going on, the bulk of the action is right down here in informal rulemaking, and secondarily in informal adjudication. Okay? Formal rulemaking is on-the-record rulemaking that uses trial-type procedures, and it is very rarely used. Very rarely used. It's very cumbersome, okay? And so it's just very rarely used. Formal adjudication is also on-the-record trial type of adjudication. It happens some, but not often. So the areas where we sort of see the most kind of formality, interestingly enough, have historically been things that involve nuclear facilities, nuclear waste, that kind of stuff. Okay, as you can imagine, very technical, very complicated, a lot of public anxiety and so forth. And so that has historically been where we have seen that. And I don't know, I think maybe there is a more recent, has there been a licensing of a nuclear power plant in recent years? For a long time, there was absolutely none. After 3 Mile Island in the 1970s, late 1970s, there was no licensing of any nuclear power plants in the United States at all. Okay, there was continuation of existing nuclear power plants, but there was no new. Right? I think there's been something recently, but some of this had to do with fallout. Anybody? None of you were even probably born at 3 Mile Island. I think it was 1979. It might have been 1978. Could possibly be 77. It was the late 70s, and there was a nuclear meltdown at 3 Mile Island nuclear power plant in Pennsylvania, and it produced massive outcry against nuclear power and massive anxiety. And so, and this was, way before Chernobyl and so forth. And it wasn't anything like Chernobyl, right? But nonetheless, people were, right? So it wasn't as bad as that, but people were upset and anxious. And then when you combine it with these very formal procedures, it basically led to an end to that. Most administrative action is all at the informal level. Having said that, it is not, when we say informal, it is not really informal at all. It just means that it's not trial-like. Okay? There's actually quite a bit required. There's a lot of process, so it is not like your professor who shows up to class in jeans, or or where you go kayaking on Harrods Creek, which is very informal. This involves notice of an intent to make some sort of rule or regulation, notice to issue a permit, notice to adopt a plan, that kind of thing. That notice is published in the Federal Register. Okay, now this is the part where you probably do want to take some notes, because that didn't appear on the slide. So when we talk about notice, talk about it's published in the Federal Register. The Federal Register is published every weekday, every non-holiday weekday of the calendar year. Okay? There's stuff coming out of the federal government that's being published every day, and as long as it's not a holiday or a weekend day, and that is those include notices of intent to make rules, etc. The agency then gathers public comments. Okay. The notice might have included a proposed rule. Okay, that's the fastest thing, just put out a proposed rule, get public comments on it, and then formally adopt the rule, okay, and publish a final decision to adopt that rule. Okay, so we get publish notice, receive public comments, publish a final decision. The final decision has to include the summaries of the public comments and the agency's response. Now, obviously, if they receive tens of thousands of comments, they are indeed summarizing. They're not publishing all the comments, but they are keeping track of which comments fall into which categories. And obviously, they can, totally ignore the things that are completely irrelevant. You want to complain about your neighbor's dog, and you write into the EPA, right? That kind of stuff. Okay. Alternatively, they can publish a notice to consider making a rule, get public comments, then publish notice of a proposed rule, get some more public comments, then publish notice of the final rule, right? Does everybody see in the second example, they're not really quite sure what they want to propose yet, so they get some comments first, then they come up with a proposal, and then they come up with the final rule. So it's 2 steps or 3 steps, but the idea is it's all, I mean, there's a fair amount of formality to all that. And they have to identify what their authority for adopting the rule is, what the purposes are, etc. Okay, once the rule gets adopted, then it will be codified in what's called the Code of Federal Regulations, CFR. Okay, the rule will be codified in the CFR. Other things will not be codified in the CFR. If it's a permit, okay, so they can go through this notice and comment process for deciding to allow the Louisville Metro government to fill in some wetlands as part of its ongoing maintenance of some roads, okay? Okay, so that might happen, and that's a permit. And that's still going to go through notice and comment, but it's not a rule. It's a specific it's a specific permit authorizing this, and so that will not go into the Code of Federal Regulations, but you can find it in the Federal Register. A plan's not going to go into the Code of Federal Regulations. Code of Federal Regulations is going to be about regulations that are rules governing future behavior by any number of parties that fall into that category of whatever's being regulated. Informal adjudication is about where there is some dispute about how a rule applies, whether it should apply in a particular way to a particular party, whether that party is entitled to some sort of exemption, whether that party has violated the rules and subject to some sort of penalties. And one of the key things there is that the party is entitled to due process. And in particular, procedural due process. And what do we know about procedural due process? There has to be some kind of notice and some kind of hearing. Okay, so instead of notice and comment, we now have notice and hearing. And the hearing is maybe open to the public, but it is, or visible to the public, but it is designed to protect the due process rights of whoever is having the law or rule adjudicated against them, right? So here's sort of a basic distinction between 2 types of decisions. One is rules and one is orders. Rulemaking is quasi-legislative. Orders are adjudication, which are quasi-judicial. And so rulemaking has either general or particular applicability and future effect. And this is language straight out of the APA. Okay, so this is just kind of standard language. So if you are dealing with this issue in practice, you're going to need to actually quote this language in your analysis, in your documents, etc. Adjudication is the application of general standards to specific facts in a final decision. Disposition, which is often granting of an individual's particularized permit, order, restriction, or penalty. All right, so where we're going to spend a fair amount of the remainder of the class today and Wednesday's class has to do with judicial review of administrative actions. And so what we're doing here is getting an understanding of sort of the basic foundations of how administrative law applies in environmental law, so that then we can understand more about, as we kind of work our way through the statutes, the specific aspects of environmental law. So anytime that you are seeking judicial review or responding to a lawsuit that seeks judicial review under the Administrative Procedure Act, you have to start with federal subject matter jurisdiction, 28 U.S.C. section 1331. And so I'm going to pause this here for a second and pull it up here. And lo and behold, it's very simple, straightforward. The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. You're like, Professor Arnold, that's so boring, so bland, so plain vanilla. Why is it there? And why is it there? Because if you do not plead it, it is fatally defective. Okay? If you do not plead federal jurisdiction, if there's a federal question involved, it is fatally defective. Okay? Sort of like if you don't put your name on your paper. Okay? The same, right? So it's just a part of understanding the process of judicial review, that there are certain boxes that you have to check in order to get into court, and this is one of them. And so, and some of you know that. Some of you, you're like, oh, wow, okay, cool. So that is different than the next item that you have to plead, which is the statutory right of action. Okay, so you have to first show that there is federal subject matter jurisdiction, that basically this federal court has jurisdiction over this matter. And secondly, if you are a plaintiff, you have to establish that Congress has provided for us a cause of action. And in particular, the Administrative Procedure Act establishes the right to judicial review for when an agency acts in an impermissible way, that is 5 U.S.C. section 702, when the agency fails to act, when it has a non-discretionary duty to act, okay, we'll get into that, but it has to be a non-discretionary duty to act, and if the agency has failed to act, then you could bring that under 5 U.S.C. sections 706.1 and 551.13. And then you also have to deal with the fact that there are some exceptions to judicial review in section 701A, such as a matter that has been committed by Congress to agency discretion by law. So we're going to talk a little bit about that. Okay? Very often, you are also, if you're bringing a lawsuit, you're also seeking to use the citizen suit provisions of particular environmental statutes. Okay? And some environmental statutes become very popular as a basis of litigation because they contain within them citizen suit provisions. The Endangered Species Act is one of those, and the Clean Water Act is one of those. And they provide some very specific causes of action that you can bring. Okay? So let's think about this again at the sort of three levels: the federal subject matter jurisdiction, the statutory right of action under the Administrative Procedure Act, under the APA, and the citizen suit provisions that authorize certain kinds of suits under specific environmental statutes. Okay? So, and I know that's not a number 3 there, but those are 3 basic aspects of this that you have to work your way through. So, if you are studying environmental law, you must study the Citizens of Overton Park versus Volpe, which is a classic in environmental law. And so what I'm going to do in these, from time to time, in these PowerPoints throughout the semester, is talk about some cases that may or may not have been referenced in the reading. The principles might be referenced in the reading. In a couple of cases, I'm just introducing the case for the first time in class, in the lecture, as an illustration of some basic principles. So don't get freaked out, weirded out, anything like that, saying, hey, I don't remember any mention of this case in the reading. Okay? But Overton Park is a classic. because it arose very early in the period of time when either we had brand new federal environmental statutes or we were seeing new federal environmental statutes being adopted. Okay, some of them weren't adopted until 1973 or so, but this is an active time. So there's a lot of environmental activism in the United States, and there is this belief that environmental law will save us. That if we turn to the courts, if we turn to Congress, if we turn to the regulatory agencies, they will help us as Americans stop the pollution of our environment, stop the degradation of our environment, and so there was an enormous faith in the legal system to stop environmental harm. Now, this is an interesting little case because, it's a classic, but because it actually has to do with a Federal Transportation Act, okay? And the Federal Transportation Act in question protects public parks, public parks, recreation areas, or wildlife and water refuges of national, state, or local significance, okay? All right, so think about this. A public park of local significance doesn't have to be much of a park, right? Right, does everybody see that? So you start reading this and you're like, oh, wildlife refuges and national significance, but if you kind of read it carefully, you get public park and local significance. Now, I'll show you the language in a moment. But anyway, so this arises in Memphis. And the federal government, and actually the local government in Memphis want to connect this freeway over here, straight across here, to 240 and I-40, right? So here's Interstate 40 coming into Memphis, right? And you guys, anybody drive through Memphis? Right? It's terrible, awful, right? Okay, so in early August, I went down to Texas. My aunt died, and my parents are elderly, and so I drove them down and so forth. And so we made our way through like western Kentucky and down through the western part of Tennessee, and they have this new Interstate 69, right? That's here and there and so forth. So there's this new, I think it's called 469, this big loop around Memphis. It's a zillion miles out. There are no gas stations. There are no hotels. There will be, within 5 years, they'll all be there. But right now, there's nothing. But it's wonderful. It's wonderful because you don't have to go anywhere near Memphis, right? You end up in Mississippi, and you just keep going. So anyway, so if you go through Memphis, you're like, ooh, this is awful, right? The traffic's awful, it's all backed up. And so what they want to do is put a connector right here, right across here. And so what's it going to do? It's going to go through Overton Park, right? What does Overton Park look like? What does Overton Park look like? Does it look like a national wildlife refuge of national significance? No. It looks like a what? An urban park of local significance, public park of local significance. Now, if you read the case, there's some like really nice aspects of Overton Park, and it's not tiny. I mean, look, this is smaller, that's smaller. There's some little parks around, right? This is pretty good size. I mean, I don't know what's that's probably 10 blocks by 10 blocks, right? 100 square blocks. I mean, that's a pretty good sized park, but nonetheless, we're not talking about putting a freeway through the Grand Canyon or the Grand Tetons or whatever, right? So, that the question is the agency, so there's the path, and the question is the agency authorized to do that and put the expressway through there? So they make a decision to do so, and there's a lawsuit. Okay, so there's we've talked about all that. So here's the statute and the specific language found in U.S. Code Annotated, Section 49 U.S.C. Section 303 says the Secretary, which is how a lot of these are worded, Okay, so very often an individual is identified, and it is the secretary of a federal department, the administrator of a federal agency, that sort of thing. That's who's identified. So, but this is basically, in essence, means the Department of Transportation, U.S. Department of Transportation, may approve a transportation program or project requiring the use of publicly owned land of a public park, recreation area, or wildlife and waterfowl refuge of national, state, or local significance only if, okay, typical statute, authority to approve this thing, this transportation program project, under that has these characteristics, basically takes away a public park, blah, 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 all that stuff, only if. So here are the requirements. There has to be no prudent and feasible alternative to using that land, and the program or project includes all possible planning to minimize harm to the park. Okay? Now, okay, this is environmental law. Okay? This is not about whether some massive industrial facility is spewing lots of black, yucky stuff into the air that's going to give your lungs cancer or something like that. That's environmental law too. Okay? It's not about fish dying in the river. That's environmental law too. Part of this is we put freeways through our public parks only if there's no prudent and feasible alternative to using that land, and the program or project includes all possible planning to minimize the harm to the park. Okay? So that's the language. And this is from the APA, and this is about the exceptions to judicial review. I mentioned there's exceptions. One of them is the statutes preclude judicial review. Okay? The statute can just plain on its face say this actions taken by the agency under the statute are not reviewable. Boom. Okay? Boom. Can they do that? Yes? Yes? Okay, Congress can do that. Okay, and what's the only limitation on Congress's authority to deny judicial review? It's a constitutional matter, right? If it's something that involves Congress infringing on somebody's environmental rights, or Congress exceeding its authority. So if Congress declares that it has all authority over all matters, state, local, federal, of any sort, and that is a non-reviewable decision, well, of course the courts are going to review that. Congress can't prevent that. But can Congress enact a statute that says the following standards must be followed by the agency, but if the agency doesn't follow the standards, you cannot sue the agency in court? Absolutely they can. They can do exactly that. I mean, it's maybe illusory, may mean the agency never follows those standards, but Congress can do exactly that. Is everybody following? Okay. So if the statutes preclude judicial review, then too bad. Doesn't matter what the APA is, you don't get judicial review. But the other exception is the agency action is committed to agency discretion by law. Agency discretion by law. So, we also have to look at section 706. This is about the scope of review. And so this language is super important. You will want to come back to this slide often. And it says, to the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. The reviewing court shall, 1, compel agency action unlawfully withheld or unreasonably delayed. Okay, so if the agency has a non-discretionary duty to do something and they are not doing it, or they're unreasonably delaying about doing it, the court can compel the agency to take the action. Okay? So that's what number 1 is about. Number 2 is that the court can hold unlawful and set aside agency action, findings, and conclusions found to be A, arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. Arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. Okay, so by the end of this course in November, this phrase should roll off your tongue. Arbitrary, capricious, and abuse of discretion, otherwise not in accordance with law. Because this ends up being the bulk of the authority, or the basis for judicial review, and the type of assessment the court is doing. The court is looking at whether the agency acted in an arbitrary and capricious way, a patently unreasonable way, abused its discretion, so the agency has discretion, but did it abuse it, or did the agency otherwise violate the law, right? Violate applicable law. So, in Overton Park, the question is, which of these applies? Is the decision by the Secretary of Transportation about whether there are any alternatives, any feasible and prudent alternatives, whether enough planning has been done, is that something that's committed to the Department of Transportation's discretion by law? Or is it something that the court can review to be arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law? Okay? Now, many of you may be sort of saying, okay, what's the big deal? Okay, at this time in the history of environmental law, we really didn't know which way the courts were going to go. Okay? So one of the big issues is, are the courts going to say, hey, there's this big amount of discretion that administrative agencies have, and we're just not going to review it? Or are they going to say, hey, we're concerned that agencies might act in an arbitrary and capricious way, might abuse their discretion, might act otherwise illegally, and therefore we're going to be busy reviewing what the agencies do to make sure that they're not violating the law. So you see where that was the big question. So, and you know what the outcome is because you're in this class, and obviously there's something here, right? Of course, the court says that the committed to agency discretion by law is a very narrow exception. It applies only when the statutes are written so very broadly, there's really no law for the courts to apply. And as long as there's some law for the courts to apply, that's what courts do. That's what, the third branch of the government, Article 3, that's what they do. And so that's indeed what they're going to do here. They're going to review the agency's exercise of discretion and ask whether it has complied with the statutory standards or either failed to meet statutory requirements or exceeded statutory limits. So let me say that again, that it failed to meet statutory requirements, or did it exceed statutory limits? Right? So the courts are going to do that. And so they ask, what are the statutory standards here? And so they say, hey, prudent and feasible alternatives. That means something. It means that the agency has to look at actual alternatives. And they have to do some sort of fact-based assessment about whether those alternatives are prudent and feasible or not. If they're prudent or feasible, then they have to pursue the alternatives. They have to engage in all possible planning. That provides some law. The courts can look at what the agency did and say, did they do all possible planning or not? Okay, so that is the basis. This is a very early foundation for how it is that courts get involved in reviewing agency actions. Okay. So let me ask this. Do you think that this degree of judicial involvement in questioning whether the agency has complied with the law or not, is that something that promotes sort of robust agency action to protect the environment, or do you think it promotes possibly sort of limits on government action? What do you think?
It seems situationally dependent, like it could help sometimes and it could limit or expand sometimes and limit other times. Also, isn't it sit a little funny that like like an administrative law judge to me sounds like an employee of an agency almost, right? I know that
none of this is about what administrative law judges are doing. None of it. These are federal district judges, federal appellate judges. So Overton Park was decided by the United States Supreme Court. Okay, so these are not administrative law judges. I mean, we talked earlier about those sort of adjudicatory sorts of things that agencies do, but this is right. We started out with the federal subject matter jurisdiction. This is district courts. So these are the federal courts. Thoughts? No? Nobody? Okay. So one of the things I want to point out here is that this degree of judicial review of agency actions is used both by those who believe that agencies are not fulfilling statutory mandates, statutory obligations to protect the environment, and they're used by people who think federal agencies are exceeding their authority, are too busy regulating beyond their authority, right? So it's both. I mean, when you say situational, I think that's exactly right? So do you see where judicial review can have both a sort of environmentalist and, I don't know what you want to call that, industry, sort of anti-regulatory element to it too, right? Okay, so that is, so in some ways, there is some degree of utility of this for sort of both sides there. So when we look at what law to apply, the courts are of course looking at statutory language, but they are also looking at the structure of the statute and the purpose of the statute. Statutory language, the statutory structure, the statutory purpose. Now, they may also possibly be looking at the legislative history. That's very controversial. Okay, there are some people some judges who think that's exactly what the court should do, and there are other judges who are saying, hey, you ought to take the language on its face. Okay, but even the more sort of strict constructionist type of judges will look at the structure and the purpose of the statute because that's apparent from the face of the statute. Does everybody see that? Okay, so when we're talking about language, we're talking about language, structure, and purpose, right? All together, right? Okay. So I just want everybody to be clear on that. So our basic analysis is judicial review available? Okay, so this is your basic sort of analysis when you have an environmental problem. Is judicial review available? You have to look at subject matter jurisdiction, standing, ripeness. Those are things we're going to deal with on Wednesday. The exceptions to the APA, is it committed to agency discretion by law? That kind of thing. Secondly, did the agency act within the scope of its authority as provided by Congress? Second phase of your analysis. Third, now we come to that language. Is the agency's action or choice arbitrary and capricious and abuse of discretion or otherwise not in accordance with the law? Okay, right? It comes directly out of the APA. That's the standard of review. Okay? So what does that mean? The Supreme Court has explained, amplified this. And one of the things they said, they say that the court is to look at whether the decision was based on a consideration of the relevant factors. It's a decision based on the agency's decision. It's the agency's decision based on the agency's consideration of the relevant factors. So what does that mean? It means that they are looking at the record to determine what did the agency consider. One of the biggest things about this is you learned all the way in first year of law school that you need to show your reasoning, right? Right? You got to show the professor your reasoning on the exam. Well, the same sort of thing goes on here. The courts are looking at for evidence of what it was that the agency considered, including the factors and its reasoning. And that reasoning leads to part B. Has there been a clear error of judgment? Third, the agency is entitled to what they call a presumption of regularity. Okay? The court does not substitute its judgment. The judges are not the agency officials. The judges are not experts in transportation planning. They're not experts in the health effects of various chemicals. That's what the agency is there for. But the court does engage in a substantial inquiry, a thorough, proving, in-depth review, and a careful and searching inquiry into the facts. Okay, these are all different terms that are used by the courts, but the general gist is the court takes a careful look at what the agency did, what the facts are surrounding this, to make sure that the agency considered all the relevant factors, made a reasonable, thoughtful choice. The review is usually limited to the administrative record, whether formal or informal. Post hoc rationalizations, after the fact, rationalizations are inadequate. So one of the areas where the agency gets into a lot of trouble is they make a decision, the record's not very clear on why they made the decision, or it appears from the record they made the decision for reason number one, and reason number one turns out to be illegitimate in some way, and so after the fact, they try to say, well, really, reason number two supports our decision. And the courts are like, cute, but no, that's not going to work for us, right? The courts are not keen on that. Part of the idea here is the courts are trying to hold the agency to accountability for good decision making. Courts are trying to hold the agencies to accountability for good decision making. Did they look at all of the relevant factors, consider the relevant evidence, apply the standards, the legal standards that they're supposed to apply, make a reasoned judgment? Can we see what the reasoning is from the record? Right? Does the decision match that reasoning? Does everybody see? That's the gist of what the courts are doing here. So I want to spend the last 10 minutes of class or so. We're going to talk about a particular case that gives some indication of some of the limits of this. Okay, so it all seems like the courts are going to be pretty engaged with reviewing what agencies are doing. Okay, so that seems to be the general gist of Overton Park. Well, there's a case that arose out of Utah. Okay? And so this is a picture of the San Rafael Swell in central Utah. And part of the issue had to do with, or the sort of core issue had to do with off-roading. Okay? Anybody do off-roading where you say, ATVs out in the desert, just anybody, nobody wanted to admit to it. Okay, so anyway, so the question is, so the general gist is that it's a lot of fun, but it also causes some damage to the environment. These areas might be wilderness. Wilderness is supposed to be, according to Congress, is supposed to be left sort of untouched from human impact or very minimal impact, if at all, and that there's habitat of species. There's sort of this beautiful views and so forth, and so we generally the idea, whether you like it or not, is that Congress has designated wilderness areas to not be really subject to all this recreational use. There's other things. National parks are definitely subject to recreational use. Other federal lands are subject to recreational use, but wilderness is not. And so this case is Norton versus Southern Utah Wilderness Alliance, and then we just call this the SUA case. The Southern Utah Wilderness Alliance is known as SUA, and so this is a SUA case. And in particular, what happened is SUA wanted to go to federal, they did go to federal court, and they wanted to challenge the failure, or what they're alleging is the failure of the Bureau of Land Management, the BLM, to manage its lands in accordance with the criteria in the Federal Land Policy and Management Act. So there's some law there, and the applicable management plans for wilderness areas. Okay, so Bureau of Land Management was supposed to, under the Act, adopt some management plans for wilderness areas, and in particular, in some of these wilderness areas, the BLM did not take sufficient actions to prevent off-road vehicles, or ORVs, from using some of the lands within what's called a wilderness study area. Now, part of the deal is that the wilderness study areas are areas that are not yet designated wilderness, but they're being considered for designation as wilderness. Okay? These are areas that are BLM, federal lands, so not national parks, not national wildlife refuges, not national forests, but BLM lands that are being considered for wilderness designation, and supposedly they're not supposed to be degrading these lands while they decide whether or not to designate them for wilderness. And so Sue was unhappy about these off-road vehicles. And you can see, you see the tracks of the ORVs out in this area. And so this is Factory Butte, Utah, and so forth. If you ever spent any time, if you have not spent any time in Utah, it is a beautiful state with lots and lots of great parks and other places to enjoy. So, whether you like hiking, horseback riding, off-road, kayaking, whatever, it's Utah's a kind of an amazing place environmentally. Okay, so this is part of, so again, the SUA cites the APA. We've already seen this language about compelling agency action unlawfully withheld or unreasonably delayed, and they're saying, hey, they need to take affirmative action to prevent these off-road vehicles from using these wilderness study areas. And the United States Supreme Court says no. What they say, actually, in a unanimous decision, is that SUA doesn't actually have the right to judicial review for the agency's failure to include in the planning process protections of these areas that are under wilderness study in their planning process. And they say that the claim under the APA for the agency's failure to perform a ministerial or non-discretionary act can proceed only if the plaintiff asserts that an agency failed to take a discrete agency action that is required. And while there are some non-discretionary standards in the Federal Land Planning and Management Act that the specific ways in which the agency, the mechanisms by which the agencies are going to implement those standards are up to the agency. The agency has discretion about how it wants to do that. So if it's going to adopt a study area or do a study area, it can take action to prevent the off-road vehicles while it's doing the study, but it doesn't have to. They can do other things to try to protect those areas. And so basically they say that the plan itself, in this case, does not create a legally binding commitment. So even though the agency had in its plan a goal of stopping the off-road vehicles, that's just a goal. It's a plan. It's not a binding duty. And so therefore they could choose other ways to protect the wilderness area than preventing the off-road vehicle. Okay, so anytime that you see a unanimous decision, right, what's going on? What's going on? And don't say bribery, right? That's not okay. So what's going on? They agree, yes, but why? Okay, how often does the Supreme Court agree? Right, okay, sometimes you get unanimous decisions in tax cases. That's just because they're all bored and they don't, it says tax, right? Right, but no, why in environmental law would you have a unanimous decision like this, right? I know, I threw tax under the bus. But anyway, why in environmental law would you have a unanimous decision? Okay, this is about regulating the role of the courts with respect to these administrative decisions. In other words, none of the justices want to see agency action or inaction. I mean, right, all sorts of things can count as inaction, right? So what they don't want to see is the multitude of lawsuits by environmental groups saying, oh, there are these statutes that impose these broad duties on the agency, and the agency isn't doing enough. Right? The agency isn't doing enough, so now we're going to sue under the APA. Do you see why, from a separation of powers perspective, justices across the spectrum might be worried about the flood of litigation from lawsuits challenging agency inaction? Agencies, they don't have enough money, they don't have enough staff, they choose to do this rather than that. All sorts of reasons why agencies have failure to act. And maybe, there's lots of reasons to sort of suggest here that the BLM should have gotten this act together and done something more, right? As a policy matter, that might be true. But as a legal duty, does the Supreme Court really want to have the courts getting in, trying to decide whether the agency should have done this or that to try to protect those lands, right? Now, one of the consequences is, some of that land's going to get torn up, right? There's going to be negative environmental impacts, but at the same time, now this shrinks the massive number of lawsuits that can be coming down the pipeline of every environmental group that's unhappy that the agency hasn't done everything that that group thinks needs to be done in order to effectuate the statute. Do we see what's going on there? Okay, so that's what SUA is about. All right, I want to give you two more, and we're almost done with this, but I want to give you 3 quick slides here. If it turns out that the agency's decision is reviewable, what does arbitrary and capricious mean? Did the agency consider the proper factors, legal standards, and did they consider the evidence? Okay, so 2 parts, really basic. This is a quote from State Farm, which is actually not an environmental case, but it's a great quote. Agency rule would be arbitrary and capricious if the agency has relied on factors which Congress has not intended to consider, entirely failed to consider an important part of the problem, offered an explanation for its decision that runs counter to the evidence before the agency, or is so implausible that it cannot be attributed to a difference in view or the product of agency expertise. So they don't care. I mean, the courts aren't going to substitute their viewpoints, but they are going to say at some point the agency's decision doesn't match the evidence on the record and or the legal standards. And so when you're challenging the agency, you have to ask what were the steps in the agency's decision, how much judicial scrutiny versus judicial deference, how much evidence, how good's the evidence, has the agency given a hard look, and in terms of the evidence, substantial evidence test or sufficiency of the evidence standard is such relevant evidence as a reasonable person might use to make a reasonable decision. Okay, it doesn't have to be a majority. Okay, so it is possible for a 60% of the evidence to support decision A, 40% of the evidence to support decision B, and the agency chooses B, and the court will defer to the agency's choice, because a reasonable person could make that decision. Right, does everybody see? Okay. All right, so we're going to stop there. We're going to turn to Chevron deference, fun times, and then standing and stuff like that. If you're doing the field trip on Friday, come see me.